And we are now recording. Okay, it's 9:30, so we're getting started. So, all right, good morning, gentlemen. We are here today in the matter of Melissa McKenzie, case number UP 23-005-8L. We are here for a public deliberation pursuant to the rules of the Baltimore County Rules of Practice and Procedure for the Baltimore County Board of Appeals. We are required to conduct a public deliberation on this motion for reconsideration. Motion for reconsideration, which was filed by counsel for the protestants, Ms. Khan. It was filed, looks like on March 19th, and a response was filed by counsel for petitioner, Ms. Scudder, on, looks like on or about April 25th, so it's sometime at the end of last week. So we are here to conduct a public deliberation on that. And with that, I guess we'll get started. Does anybody have any thoughts about where we stand with this? I mean,
I'm happy to go first if you want me to, or you guys can, whatever you want.
it doesn't matter to me. I can go first. You can go first. I mean, my initial opinion is, well, I mean, we're required to operate under the rules of the Baltimore County Board of Appeals. So in looking at this, I mean, the motion was filed March 19th. The opinion was issued February 13th. So obviously, I mean, the rules state a motion for reconsideration must be filed within 30 days from the date of the original order from the opinion. So we're here, we are 5 days past that, looks like.
You know what? I actually thought about this, and I think maybe that might not be correct. So we got an email from Ms. Khan sending us the motion for reconsideration. I think it's on March 18th at 10:45 p.m. is what the email says. Is that
That's still 5 days beyond the 30 days. Well, how many days in February? Let's count it up.
well, I mean, I counted them out, but you know, I think what day was our opinion issued?
February 13th.
The 13th? Hang on one second. February 13th. Okay. All right. So we will silently count this. That's a,
Well, there are 28 days in February, so that's 15 days. And then 15 days after that is the 15th of March. I mean, that's how I would look at it. Is my math? I mean, I know lawyers don't do math well sometimes,
no, we don't.
but is that how you see it, Mr. Pennington?
That's, I mean, the days, yes, you're right. Day 30.
Day 30 is Saturday.
An extra day, it's still
Even if
Day
you
30
give it until the following business day.
is Saturday the 13th. Day 31 is the 16th. Day 32 is the 17th, and day 33 is the 18th. And I'm also factoring in the mailbox rule.
Does that apply to us?
I think it does. I looked up because our rules say that we're subject to Rule 1203, which says if you get a notice in the mail, you get 3 days afterwards.
This was an email, wasn't it?
I don't know if our orders technically go out by mail or by email. I mean, I think they're mailed, but I don't actually know the answer to that question. I mean, I'm Yeah, the 18th is day 33. I mean, I'm kind of inclined to grant to give him the benefit of the doubt on that because I don't know the answer to the question. But um, I regardless of what you guys think about that, I think we should still talk about the substance of the motion just to kind of, you know, fully discuss it.
Right. I agree. Anybody have any thoughts then? Moving forward?
All right. Well, I'll since I'm already jabbering here, I think that the whole thing turns on the fact that the movements are their primary argument is that the property has been rezoned to RC5. And I think the whole thing turns on the fact that up until they filed the motion to reconsider, they never brought it up to our attention. There's nowhere in the factual record that property was rezoned. And, we're bound by the record. If you don't tell us something, we don't know it. And I think that, I think there's a secondary issue, which is, even if it was true that it was reclassified, would that even matter, based on the permit already having been issued? But I would listen to your thoughts on that. I'd like to go a little bit more into the memorandum and some of the things they say, but I'll defer to you first.
Well, my thought, can you hear me?
Yes, sir.
Okay. My thought is whether they brought it up or not probably doesn't legally matter. If it did, is the board still in the process of making its decision when we are considering the motion to reconsider? Is a question that it would have for us. And if the answer to that is yes, then if the zoning changed, whether they brought it up or not, during the time that we made the decision, and now, basically, our motion to reconsider, then the zoning change seems to me to be, quote, relevant. Okay, are you following my logic here?
Hold on. Are you saying that if the zoning changed after we granted the permit between that
No.
date and now?
Well, is our decision final? When's our decision final?
I think our decision's final when the opinion's issued.
Okay,
That's the date. That's the final order.
okay, and not upon reconsideration by the parties after our opinion is issued.
I think so, and I'm going to tell you why.
Okay,
Because our rules for reconsideration specifically say that we're not allowed to take in extra testimony if we do hold a reconsideration.
okay,
Well, we can.
Okay, I'm wrong about that. That's not true.
We can after the public deliberation.
Right.
Can actually order a hearing to
But again,
additional testimony if we so chose.
if it was true that the property was rezoned, it's not enough to just say that in the motion to reconsideration. There has to be some evidence that's brought to our attention of the truth of the matter. The motion for reconsideration doesn't say when the property was rezoned. It doesn't say if it was rezoned before our initial hearing, It doesn't say if it was rezoned after our hearing. It doesn't show any evidence that it actually was rezoned. If it was true, it would have been easy to append an exhibit that shows that the property was rezoned. And that was not done. So I still think that we don't have any knowledge of the fact of the rezoning to take into account.
Yeah, it was not clear to me, nor the effect of the rezoning. There was just some general allegations regarding the rezoning that it might have an effect on this this facility. But I don't think they were specific in my review of it anyway. Maybe you all caught something, but I didn't see anything specific saying that it's not permitted per se, you know? I didn't see that. Now, having some familiarity with this issue of retroactive application of laws related to zoning decisions, that's where my reluctance comes in terms of us moving forward. And my thought is this, I mean, I had a matter that was 10 years in the process because we needed to go through the court system, and then it came back and it dealt with similar issues related to this case in terms of retroactive application of, this was not a zoning law, but this was a statutory change that affected the zoning law. And my reluctance is in terms of the substance of the motion to reconsider. Not, I feel pretty comfortable about the motion to dismiss based on the dates, you know, but if you're all, the mailbox rule applies, but my gut tells me, okay, that we ought to ask the parties to file memoranda telling us about this zoning change and the effect on the use permit. That there has been, there's been argued that there's a change in zoning to RC5, and that zoning has an effect on the use permit. And if the date thing is okay with everybody in terms of when the reconsideration was filed, my gut says we ought to, rather than saving everybody the appellate court process, is try to understand that zoning change, because that zoning change, whether they told, in my opinion, whether they told us or not, if that happened during the time that we're considering the matter, or the courts are considering the matter, may have an effect upon the case and the use permit. That's my, and I would really like your thoughts on that, and I could be way off, and I, you know, whatever.
I mean, I think that the parties, specifically the parties who are motioning for the reconsideration, had an opportunity to do that when they filed the motion. And I just think there are no facts that are built into this motion. There's no persuasive authority that's built into it that tells us how we ought to rule. And I hear what you're saying, you know, but I don't think we're here to save people from themselves, when they've been given every opportunity to state their position for the record. I don't know, Mr. Chairman.
I agree with you, Mr. Stelmack. I mean, the opportunity was there. They filed the motion. And just like both of you, I can't figure out if and when that zoning was changed by any of the evidence presented, anything provided in the motion for reconsideration.
And that wouldn't have been hard, if it's true, it's a matter of public record.
Right.
Right.
So I agree with you, Mr. Stelmack, on that issue. So where does that leave us? So we have the timing issue. Right.
I mean, if you gents want to go off the record and think about that for a few minutes, I'd be, I'd probably would do that too. Couldn't hurt. But that's up to you.
I don't think we need to go off the record. I mean, let's
don't.
figure it out one way or the other. Either there's some kind of mailbox rule that applies, or there isn't a mailbox rule that applies, right? Of some sort. And either we decide it's either timely or it's not timely. I mean, it's and we've counted the days a couple times here. I haven't taken my shoes off and rechecked, but it seems to me that it's outside of the 30-day window. Mr. Chairman,
No, I mean, I believe it is outside the 30-day window.
All right.
But I think
I'm going to count one more time to myself.
What's that?
I'm going to count one more time to myself. And if I think it's within the 30 days, I can dissent as to that one point. So let me do that real quick. I mean, I think that the 18th is the 33rd day and that it was filed at 10:45 p.m. or thereabouts on the 33rd day, which, if the mailbox rule applies, which I think it does because of Rule 1203, then I think they're within the technical filing time.
could you read that rule again to us, Mr. Stelmack, if you
Yes,
have
sir.
it?
This is Maryland Rule 1203. C. Whenever a party has the right or is required to do some act or take some proceeding within a prescribed period after service upon the party of a notice or other paper, and service is made by mail, 3 days shall be added to the prescribed period.
Did the business day end on the 18th at 4:30 or 4 o'clock?
We don't have a rule that talks about that, as far as I know.
Right.
You thought about this, I could see.
I have
Well,
not.
and also
I have thought about the fact that we don't have enough rules about motions, but also whatever. I mean, if it was filed in the circuit court, would it be late? I don't think so because we have electronic filing now. But if it was filed in federal court, it wouldn't be late because they have electronic filing and it goes to the end of the day. If it was filed
Before,
in orphans court, it would be late because they only take stuff until 4:30.
right. And I just remember back in the day, like, before electronic filing, especially federal court, they had drop boxes where as long as that was there before midnight,
Right.
it was counted that day. But
I mean, I think the fact that we allow people to email stuff in, unless we specifically tell them, I mean, sometimes we say this must be filed by 3:30 on a particular day or whatever. You know, if we don't specify that, we give people the opportunity to file by email. If they file it by the end of the day, like I said, I'm inclined to give them the benefit of the doubt.
okay. So then where are you now, Mr. Stelmack, with the rest of it?
I would still deny the motion. And because of the issue that they specifically, because they never raised the issue. And in fact, and I'll say this too, I think they specifically concede that it's DR 3.5. And that's in their memorandum, their closing memorandum on page 2. They basically say it's DR 3.5. And I guess there's, you know, if you look at their argument, it's that the zoning was changed before the hearing, I guess. I don't know if that's true or if that's just something I really don't know because we
I
have
don't
no
either.
way
I
of
can't
knowing.
tell.
But if it was changed and then in their closing memorandum, they essentially said, no, it's DR 3.5, then, I mean, you know, again, they've never raised the issue of the rezoning until now.
So
And
much
they still
time.
haven't provided us any evidence of it. And also, I hope you don't mind if I just, you know, there are things in this memo for reconsideration that, I mean, concern me a little bit. You know, I think I'm at the bottom of page 5. You know, it says procedural deficiencies in the approval process further complicate the matter. Testimony from Mike Chirico suggests that the board may not have been fully informed of the zoning change, or alternatively, chose not to consider it during deliberations. Well, yeah, no one told us about it, so why would we? Further, Councilman Marks' willingness to have the new People's Council raise the issue indicates that even county officials were unaware of the board's stance on rezoning. What does that even mean? We have no indication that People's Council is involved in this matter. Why would we know that there's testimony from this gentleman, Mike Tirico, outside of our proceeding? Why would county officials be unaware of our stance on the rezone? I mean, all this things that are mentioned in this memorandum presuppose that we have some level of omniscience about what's happening outside the board that we do. I mean, Fred might, but I don't.
I know.
I just don't understand where this stuff is coming from. And I want to specifically bring up another issue that's raised, which is this. And this is the middle paragraph on page 6. It says, inconsistencies in communication and potential due process violations further undermine the integrity of the approval process. The email chain reveals delays and possible miscommunication between the Board of Appeals and legal counsel, I don't know who's legal counsel, regarding the submission of memoranda and certified mail receipts. If relevant arguments or evidence were not properly received, reviewed, or acknowledged, the community was effectively denied a full and fair opportunity to present its case. In light of these issues, the board should grant the motion to reconsideration. And what I think they're talking about here is the fact that the closing memorandum from the protestants was not filed timely. It was filed by mail through some sort of certified mail system, and it got here late. And I don't know why it's on us. I don't consider that really to be a miscommunication. But even if it was late, I think we still considered it. I just don't think it was persuasive at all.
Right.
Yeah, I know I reviewed it anyway, our decision, before our decision, so. I think we all did.
I mean, yeah, I mean, we didn't hold it against them that it was late. You know, sometimes through the best intentions, things don't work out the right way, but we still considered it.
Mm-hmm. It's all part of the record.
That's all I got.
Okay. All right. So I am with you. Regardless of the date of the timing issue, I vote we deny it as well for the same reasons as you stated. The whole zoning issue, which wasn't brought to anything, was brought to our attention until March 19th in this. So that's where I am.
My feeling, Mr. Chairman, is that we deny it also, but more specifically because they were not clear in terms of what effect this zoning, this proposed, from RC2 and RC5 from a DR 3.5 has. You can't just say, oh, look at it because it may have an effect. If
Yeah, I
they
mean, there's allusions in there.
more specific related to the granting of this use permit, as it relates to what the granting of use permit in a DR 3.5 it means, as opposed to the granting of use permit in an RC in the RC district. What's the difference? And I didn't find anything in there of substance to do that. So there's nothing for us to really look at, if you will. If they said because in an RC district, this is not allowed, it's not allowed within a certain whatever, requires certain special exception, whatever, that would be a difference. But I didn't see them allege in the memorandum that they filed on the motion to reconsider any specifics related to that zoning change and what effect it might have. So
I think you're right. Yeah.
I just didn't see the substance there regarding that. That's my thoughts.
Okay.
I agree with Mr. Lauer, and there might be something in there, you know, somebody told us this or that, but there's no actual framework of an argument.
Yeah, show me the law. Show me the
Show us
law.
if it was changed. Show us when.
Yeah, or that it actually happened.
Right. Okay.
All right, how do
So
we
we're
want to
gonna
rule on the timing thing, Mr. Chairman?
Yeah, that's what I'm just pondering here.
I think, given everything, we ought to just go ahead and accept the motion for reconsideration from them. I mean,
I'm fine with that.
okay.
Yep.
You
So
can,
would accept the motion but deny relief.
correct. Okay,
Everybody good?
I'm good with that.
Okay. Mr. Stelmack, you good?
Yeah, I'm good. Thank you, gentlemen.
Thank you. Thank you, Mr.
Seeing
Chairman.
y'all.
Stelmack.
I'm gonna stop the recording.